Okay, I just wanted to get started. I'm Will Schroeder. I serve on the Montgomery County Corporate Volunteer Council Board of Directors. I'm also an attorney here at Shulman Rogers in their commercial litigation department, and I just wanted to welcome everyone for coming and also just note a few thanks up front. First, I guess I need to thank and ask Jeff Miller to stand as our sponsor. He's with Action Coach. He's a director on the CVC board, and he's a great proponent of small businesses making a big impact in the community through good corporate citizenship. So I want to thank him very much for sponsoring our luncheon and workshop today.
In addition to the Action business that I've had for the last 11 years, I'm also president of Jeff Miller Consulting Alliance. And one of the things I always ask clients, I ask people, what are you doing? What's the one thing you're doing to make a difference? And as business owners, as members of the community, I'm currently in the class of Leadership Montgomery. I can tell you there's the narrative of Montgomery County, there's the reality with the gaps, and really as business owners, as people involved in the community, it's really up to us to make sure we're doing one thing to make a difference.
Thank you, Jeff. I want to thank Pep's Catering for the great bag lunch that we're having. And I want to thank Planet Depos for providing the videotaping services. We are videotaping today. They're providing this service for us at no charge. They're going to be doing a teaser video that we're going to have up on the website, and you can see the whole seminar online through YouTube. And then, in particular, Planet Depos is an up-and-coming report recording service in the county. I know that Stein Sperling also uses them. Our firm uses Planet Depos. They have 60 offices worldwide, and in particular, I just want to thank Teresa Smythe and David Andre for representing Planet Depos today. I also want to introduce our presenters. The first is Bob Canter. He's a shareholder in our firm's tax-exempt department. He helps tax-exempt organizations all the time with these kind of issues that we're going to be talking about today. And then I also want to thank Mark Schweighofer from Stein Sperling. He's in their tax department and answers financial questions for businesses as well as nonprofits all the time as well. And today we're going to be talking about the duties under the law that directors have when they serve on the board of directors. And on the outline that you have on the materials in front of you, I wanted to just quickly direct you to the little disclaimer in the footnote at the bottom. You always have to read the small print. But especially if you're in a law firm. Yes. And our discussion today is for educational purposes. The presenters and I are attorneys, but we're not providing specific legal advice today. As officers of the court and as public servants of the law, we have our mission to educate and inform. So hopefully today you'll find the information helpful. But if you have specific legal questions, every case, every board, every director is different. So we'll be available separately afterwards to answer, hopefully, any questions possibly that you might have. But today we're just going to talk generally about the basic core principles of what it means to be serving on the board. And I guess I'll let Bob start us off.
Okay. Well, I think we'll, if it's okay, we'll be seated. So, since the microphone's here while we're speaking, it's a pleasure to be talking to the CVC about the duties of directors. I know I gave a similar speech together with another attorney about 5 or 6 years ago, and probably we've had turnovers and different directors since then. But it's a subject that I think is extremely important. It's important in part because all of these people, all of you who are committing your time and effort to being directors, first of all, it's a thrill to be with people who've got this kind of commitment to the community, but it's important that if people are directors, they understand, first of all, I think, what they really need to be doing as directors. Now, probably the people who are here, you're the people who are committed and really understand that it's important that you take the job as seriously as it should be taken, but to the extent there are people who don't really know how important a job it is as a director, please learn it. Please make other directors on your boards aware of their legal obligations as directors, and also there's some protections to protect them against unnecessary legal entanglements. So with that, let me turn to tell you initially what we're going to cover here. We're going to really break this down into sort of three different areas. One is just what are the legal duties of directors? I mean, they're prescribed by statute, they're prescribed by sort of a history of law, I hate to say it, lawsuits that have come against directors in the past for not fulfilling their duties. Then we're going to turn to cover what legal protections are afforded to directors, because the states and even the courts have recognized that you do need to encourage people to be directors, and if they follow sort of statutory rules and act in good faith, they can be protected from unnecessary or inappropriate legal liabilities. And underlying all of this is, and we're going to talk about this in the context of the legal duties of directors, but underlying it all is, there's a level to which somebody has a minimal legal duty to do something, but certainly best practices says you go far and away beyond what is the minimal duty that would say, okay, I can check the box. I've fulfilled my duty to, quote, be a director. And let me cover first sort of what the statute in Maryland, like the statute in many states, describes what's the duty of a director. Now, interestingly, Maryland, unlike some other states like the District of Columbia, doesn't have a full sort of portion of the corporate code devoted to nonprofit corporations. And actually in Maryland, they're called non-stock corporations. So every nonprofit that's formed as a corporation in Maryland will be formed under this portion of the corporate statutes for non-stock corporations. But if it's not specifically covered in the non-stock corporation law, provisions, then you go back and you look what is it covered in the normal corporate stock corporate provisions, which apply to stock corporations as well. So statutorily, the duties of a director in a non-profit corporation formed under Maryland law are the same as they are for the director of a for-profit corporation. Now, you may not have heard of a tremendous number of cases of directors in nonprofit corporations being sued or being held accountable for legal liability, but certainly you've heard of directors in for-profit corporations, including a lot of large corporations, named Enron, WorldCom, companies like that, where the directors end up being subjected to lawsuits. So the statutory standard is fairly straightforward. It basically says that a director shall perform, and it says his duties, so I'll read it out of the statute, his duties as a director, including his duties as a member of a committee of the board in which he serves, number one, in good faith, number two, in a manner he reasonably believes to be in the best interest of the corporation, and three, with the care that an ordinarily prudent person in a like position would use under similar circumstances. Pretty succinct, pretty straightforward standard, and behind this standard there are there's hundreds, thousands of cases, both in Maryland and elsewhere, interpreting what do these terms really mean. When you boil it down and you look at your duty as a director, the director has what's called a fiduciary duty to the members of the organization. Fiduciary duty is a higher duty than just simply just a simple duty, but it is a standard that you're held to. And there's three primary fiduciary duties. And Mark and I will cover each of them separately, although there is a degree of overlap between the three duties. First is duty of care, duty of loyalty, and then third is duty of obedience. And I'll start with the duty of care. The duty of care sort of focuses on really the decision-making process. How to be engaged as a real director, what do you have to do? It's not, it's really a subjective process of how can you actually perform your duties to help run the organization. And unfortunately, with a lot of boards of directors, or a number of them, they'll bring somebody on because they think the person is somebody who can help them solicit funds. The guy, man or woman, has a reputation in the community. You think that they have contacts, that they can help bring money to the board. That's great, but they have the same duty to act as a board member as somebody who is there plotting in the trenches and plotting out, okay, what do we really can do? And you do find there are board members who, it's nice, you can, quote, put it on your resume, and they don't really attend things. Or if they attend meetings, they attend them, but they don't really read anything ahead of time. They don't give any thought to the job. They're not fulfilling their duty of care. They're not, because the duty of care says that a director needs to be engaged. They need to take seriously what the mission of the organization is and what needs to be done to protect that organization, to keep it on its mission. Generally, the director doesn't have to be perfect, doesn't have to always make the right decisions, but they should go through the process of interacting with the other directors, understanding what's going on with the organization, avoiding the guilt by omission. The director who said, I was too busy for it, I'm on the board, but gee, I didn't know this was happening. I didn't know there were problems with the organization. I didn't know we had hired people who have a criminal record and they're dealing with children. You know, things like that, that you can't escape that by simply saying, I'm on the board and I didn't know. The board acts as a board, and this is general law for for-profit corporations as well as for nonprofits. And it's a deliberative body. So it's important that the board actually have meetings and where board members who hopefully have prepared for the meeting ahead of time can exchange ideas. And the point of a board meeting is the exchange of viewpoints between the various members on the board. You should have the opportunity to ask questions, to get questions answered, to ask the hard questions. And if the hard questions or even the simple questions aren't answered at a current meeting, to delegate to somebody the responsibility to come back with the facts, to help fill it in. And I know some boards act, some organizations act as well. The CEO of the organization will give a call to somebody. I just want to run this by you. Is this okay? And they may never have or rarely have actual board meetings. That's a mistake, because it's not functioning as a board when the founder or CEO, executive director, simply calls people up and bounces things off of them, but you never have the opportunity to actually get together, or we rarely have the opportunity to get together as a board to flesh things out by passing it, comments and thoughts back and forth amongst each other. Yeah?
Shouldn't that, the number of meetings and attendance requirements be in the bylaws? Am I jumping ahead?
No, you're not jumping ahead, and I'll answer it. If people have questions like that, it's fine. The answer is most bylaws don't dictate a specified number of meetings per year. Some do, but they sort of leave it up to the board itself to dictate how many they'd have. I do know a number of tax-exempt organizations, charitable organizations, wrestle with the question of what do we do when we call a meeting and we can't get a quorum for the meeting. Our bylaws says we've got to have half of the directors in order to have a quorum. Well, we've got these people on the board, and they're all busy. They got other things to do, and this is a volunteer organization. And, you know, we call a board meeting, we don't get 50% of the people there. We can't actually have a board meeting. I mean, my answer to that, and it may sound a little harsh, is you've got dead wood on your board, and you really do have an obligation as a board to make sure you're able to have the meetings, because so that if people who really aren't going to be attending, I hate to say it, terminate them from the board. And, you know, they may be people who have, you know, sort of a star feature to their name because they're recognized people in the community. The answer to that, and a number of organizations do this, is you have your board of directors, which are the people who run the board, the organization, who make the decisions, who honestly look over the shoulder of the executive director and make sure the executive director is doing his or her job. You can also have an advisory board, and advisory board has an advantage because you're not asking these people to come. They can come perhaps, unless you bar them, they can come to regular board meetings, but they're not going to have a vote. They're also not going to have the responsibility for being held accountable for mistakes that the organization would make or for things the organization doesn't do properly. So it's a good way to give somebody the credit of, they're a contributor, they're a person the organization values, but they're not responsible for making decisions, and they don't get counted when you worry whether you have a quorum.
Bob, just briefly, first of all, I forgot to mention that if you do have questions, feel free to raise your hands. And if, in particular, before we move on to the duty of loyalty, which is coming up next, as I understand it, the duty of care really involves just reasonableness. What is reasonable? Does anyone have any questions about what the reasonable obligations of care or responsibilities would be for a director before we go on to duty of loyalty? Do you have any? I mean, you've listed in the materials, I think, a great number of things to consider, and I just want to make sure we have enough time and
I mean, the one thing I'd say is, the duty of reasonableness allows you to rely upon comments made by the council, the accountants, the other folks who are giving reports to the organization. So it means to just take that into consideration and make a reasonable decision. You're not held to perfection, but you're held to actually looking at the material, thinking about it, and then making a decision that's within the broad range of reasonableness. And then I'll turn it over to Mark to talk about the duty of loyalty and the duty of obedience.
Great. Thank you very much. And Will, again, thanks for hosting, and thanks to Shulman Rogers for hosting. The next area that we're going to move into is the duty of loyalty, and kind of echoing and piggybacking off of Bob's comments. It's on all of these duties, you're going to see kind of the theme. It's not necessarily the destination as much as it is the journey in terms of how you get to where you end up. Duty of loyalty is something I think, though, that probably deserves a little bit of time and pause to kind of focus on, and it's something that I think a lot of nonprofit organizations struggle with to some extent. And it's because you have situations where where you're serving on the board of a nonprofit, you're supposed to put the goals and objectives of the nonprofit first and sort of forego any sort of simple or any sort of personal investment or personal benefit. And it goes a little bit broader than that because it can actually go towards organizations that you serve in or work for, or as well as organizations that maybe relatives work for. And we'll kind of work through some of those issues. And it's dicey because it kind of comes up in some instances. You may have a conflict, and it may not necessarily be bad. In fact, that conflict may actually benefit the organization, may benefit everybody that's involved in it. Potentially, you have a board member who can provide a service that the nonprofit needs. Perhaps they're willing to do it at a discounted rate. There are ways that you can do this, and that's not a bad conflict. It's just something that has to be disclosed and kind of have to be worked through. So the duty of loyalty really comes down to sort of three separate duties is the way I kind of think about it, at least in the nonprofit space. One is like sort of the conflict of interest, and I'll spend a little bit of time on that in a second. The second is sort of the corporate opportunity doctrine or the organizational opportunity doctrine. And basically what that is in sort of a nutshell is, as a board member, you should not be taking opportunities that your organization can and may be interested in pursuing. So it may be something that somebody brings an opportunity to buy a piece of real estate or something that that the organization needs space for. And if you as a director decide to buy it first, that would obviously be, that would be usurping a corporate opportunity. There are procedures you can put in place, and you should have procedures in place to sort of deal with that, that opportunity should at least first be offered to the full board. And then the final part of it is sort of a confidentiality obligation, which is more or less just making sure that, the inner workings of a board of directors and of an organization, you're going to have some comments and some deliberations that you don't necessarily want to be sort of front page news. And that's one area that I think it kind of makes sense to, to have in having a conflict of interest policy, and I'll talk about that in a second on what that should be, that addresses that, the deliberations, the communications between the board members are supposed to be confidential. Now that doesn't, you kind of have to tread a fine line there, because there are whistleblower statutes and things like that obviously trump that can trump that confidentiality obligation. But those are kind of what I see as sort of the three sort of paramount duties under the duty of loyalty. One of the things that I think that's really important for all nonprofit organizations to have is a written conflict of interest policy. It's important because one of the things that the IRS asks about it. If you look at a Form 990, it's one of the questions that they ask for on whether or not there is a written conflict of interest policy in place. The IRS actually publishes a conflict of interest policy on their website. I don't find that one to be particularly great or useful. I think it's a little bit cumbersome. It's designed for a healthcare organization, if anybody's ever taken a look at it. But it does, but if you want to get an idea on what's there, on what a conflict of interest policy sort of looks like, that at least gives you sort of a starting point. And again, it's not, they vary, depending on the type of organization and the organization's needs, they're going to vary, across the board. Two elements that I think are almost always there, however, are some sort of an affirmative duty on the directors of the board to affirmatively disclose organizations that they may have a conflict of interest with. Some nonprofits that we've worked with in the past go a step further, and they actually send out sort of annual questionnaires where people sort of list the organizations they're involved with, so that they can kind of identify it up front. It's tough because, like I said, the duty of loyalty sort of spans more than that. It can encompass family members and other organizations, so it can be it can be kind of difficult, and it really has to be sort of analyzed on a case-by-case basis. But that's one of the things. So the first thing that a conflict of interest policy should have is the duty to affirmatively disclose. The second one is to basically have an obligation for the conflicted director to abstain from voting on the matter. Now that doesn't mean, and I've seen conflict of interest policies where they basically, after it's been disclosed, they sort of, what the policy will say is at that point you're supposed to kind of remove yourself from the deliberations. That, I'm not sure, makes a lot of sense, but...
How do you disclose? I mean, just in practical terms, if you're not sure, what do you do? How do you disclose a potential issue?
It depends. I think you have to look at the issue involved, depending on how the conflict comes up. I mean, we have some hypotheticals later, I think, that will, raise some specific conflict of interest issues. But really, it's advising the board, the rest of your board members, that this issue exists, so that before a vote, occurs on a matter, they understand that there's an understanding that there is potentially an interested party on the other side of it that's going to benefit in some way, shape, or form. Yeah, we had a question.
Is there also some law? I guess there's case law or something, or is there any directive or direction to that? Say that is kind of a situation, is there some stat to recuse yourself from voting? Okay, we need a new roof. Well, Will happens to be in the roofing business, and he's
That's right.
A board member. That's not why he joined the board, and maybe he knew the roof was going to go bad in 10 more years, but is there a way he doesn't vote, and then I don't know, you guys have to decide, the board has to say, we can't use his business.
That's not it at all. You can use, what you should do is, again, it's like I said before, it's the journey, not the destination. As long as Will's not voting on it, that may be perfectly fine. What you want to make sure you have an opportunity to sort of go a step beyond just taking his bid. You may need to go out and look at other bids. You may need to, and it gets back to sort of that reasonableness standard that applies in the duty of care context as well. that says, look, we're going to go out and we're going to kind of, we're going to investigate whether or not this makes sense for the organization. And like I said before, it's not that all conflicts of interest are bad. Will may actually be willing to donate his time, or
You just
do
lost
it
your
at,
profit right there.
right. So you're so it may be that it's and if it's an otherwise reputable reputable person, reputable opportunity for the organization, it's okay. It's just important to have a policy in place to deal with these issues as they sort of come up.
If I may say, it also comes back to fiduciary responsibility. So
Right.
if a board member can provide a service that's cheaper and they go out and get estimates and several
Mhm.
bids, then I think, in different boards I've worked with organizations, that the fiduciary responsibility says do spend less, do what's best for the organization. So
Of course.
I didn't realize, I always thought if there was a conflict, if a board member was on a board, they could not provide a service. Now I'm learning something new, that they actually can.
Yeah,
As long as
absolutely.
it's disclosed and it's in the best fiduciary interest, that's two reasons right there, correct?
Correct.
It's absolutely done all the time, and in fact, that the board members may have dealt with the principal of the company who's on the board does give that person a little more credence. You know that they're a person who's reliable. So, but yeah, you should get alternative quotes rather than to simply go with the board member who says, I'll do it at, even they say I'll do it at preferred rates.
Right.
Well, and this is really important for nonprofits because a lot of times your directors are professionals, they have their own businesses, they have resources and knowledge that it would be unfair to exclude from the board. Again, I think the key thing that you're saying, Mark, is that it's a process. If all the information gets out and everybody on the board is understanding, listen, so-and-so has this opportunity and wants to provide it to the board needs to understand where the interests lie.
Right.
And go through a reasonable process of decision-making, not so one person gets favored over another or anything like that, but as long as you follow the process, I think that conflicts of interest can be resolved as long as they're done up front.
Up front, and it gets back to Bob's point about really the importance of having full board meetings and being able to kind of flush these issues through the entire board rather than kind of doing it on a one-off. Having one person make a bunch of calls, it gets a little bit messy and dicey in that situation.
We have another question here.
Oh, I'm sorry.
How do you document if a board member says, hey, I suspect I might have a conflict here? Does it go in the meeting minutes? Or?
I would put it in the meeting minutes.
Okay.
Absolutely. Yep. Absolutely.
Do we have more questions on the duty of loyalty? Yes.
Just one more
Sure.
question. I'm not sure how to explain this because it doesn't make sense in the roofing example, but I'll take the roofing example. So you're on the board and let's just say you're a roofer and you're a nonprofit. It's a nonprofit and they have to have something to do with roofing. But they own 10 houses and the 10 houses need new roofs. And you're going to give them all away for free. Okay, so there's a reason why you might be doing that. Maybe that's helping your bottom line because that's what you give away per year. Is that a conflict of interest?
Don't look a gift horse in the mouth, I guess.
Right, that's
I'd say it should be disclosed.
Right.
It absolutely
That's
should be
right.
disclosed that, I'm a principal in this roofing business. I'm going to do the roofs for free.
But you came on the board to do that. I mean, that's kind of what you're giving back. So
I would say it's disclosed and you can take the
I mean,
benefit
this
of it.
example
The
doesn't-
only benefit they're going to get out of it, and that's what you weigh, is they might be able to use it in their advertising. We roof the poor or the
Right.
needy.
Or-
That's right.
But you're not, if you put out a competitive bid, I think it's probably a waste of time. You're not going to find somebody else to step up to the
That's
plate
right.
and do it for free. So I think in that case, taking it for free, in my view, would be fine. But again, document that you discussed
That
it.
it's been out there. That's right.
Well, and that the advantage is identified. A lot of times, people and companies are doing things for the right reasons, but there's also, and this is part of the CVC, when we network, we understand that things are and opportunities are going to come about. As long as the board has a discussion and understands that this roofer is going to put on their website or something, by the way, I'm going to market and get advantage from making this donation. If the board understands and approves that, that resolves the conflict of interest, doesn't it?
I believe it does. Yep.
Let's move on to the duty of obedience.
Yeah, so the duty of obedience is basically what this duty imposes on directors is basically making sure that the organization is complying with a couple of things. One, just sort of general legal compliance. Making sure it's filing its Form 990 or 990N if it's a tax-exempt entity. Making sure payroll taxes are filed and paid. Making sure sales and use tax returns are paid and are filed and paid if required. But the other one, and kind of the broader one, I guess, is just making sure that it stays that you're staying true to the organization's mission and organization's sort of their purpose. And with that gets that generally requires board members to know what that purpose is, and to read the organizational documents, or if there is a mission statement out there, to make sure that mission statement is read and affirmed every year or every so often. When new board members are brought on to the board, make sure they understand exactly what the organization's mission is and what it is not. Now that can change over time. We'll talk about that a little bit later on. But you don't want to get too far afield, or you run from what the actual the mission or business purpose or purpose of the organization is, or you can run into some issues potentially with for liability to outsiders, including state's attorney generals who can potentially bring claims for saying that it's basically the organization's exempt purpose or nonprofit motive. It's set forth in filed documents with the state generally, so it's something that everybody can see. When you get far away from that field, you run the risk that you're violating or breaching a fiduciary duty. I didn't have a whole lot more to talk on that part. I know we want to keep on.
Yeah, let's go.
So we can just kind of go to the.
Well, let's go to the big question. What happens when you get sued?
That's right. So now we're in the. So we're almost through the part where we scare you all, and then Bob will come in at the end and kind of shine a light on everything. So one of the other things is once you're getting sued, one of the questions is, well, who can sue you, and what are the liabilities that can come up? Well, one of them is the Internal Revenue Service is a big one. The Internal Revenue Service, especially and this kind of arises in the duty of loyalty context, where you have sort of transactions where there is a benefit, an excess benefit that's provided to an insider or somebody who's basically the text of the statute is actually kind of squishy, but it's basically anybody who's in position to substantially impact the direction of the organization for the 5-year period that ends on the date that the transaction occurs. Is potentially subject to something called intermediate sanctions. And that's basically where you have a situation where the insider or somebody's getting a benefit greater than what they should have in the transaction. So it's like, you sell the nonprofit a piece of real property for more than it's worth. Or a situation where you buy something for them for less than it's worth. And so you have those situations, and the penalties can be kind of severe. It's basically 25% of the excess benefit, and it very quickly escalates to 200% of the excess benefit. So it's a pretty significant penalty. And then even if you're not the person who benefited from it, if you're on the board who approved the transaction, you face the prospect of being penalized up to 10% of the excess benefit amount, up to $10,000. So that's, so one of the main people who can or main entities that can bring claims against boards of directors is the IRS. So that's one of the things you want to really make sure why the process is so important and that these things are vetted. In other instances, you'll have other board members who may bring suits, basically saying that some of the board members have sort of abdicated their responsibility and aren't living up to their standards. So there are cases on the books that have that. Depending on the scope of the nonprofit and what exactly it does, nonprofits are sort of unique because they don't have owners per se. But they may have members, so if you have sort of a business league or something like that where people pay dues, particularly. You may have a situation where, that one of the members of the organization can come back and say, the board is kind of squandering whatever we're doing, all of the donation or our annual dues, and so we're saying that that's not in keeping with the organization's exempt purpose. Donors. So, nonprofit entities rely heavily on the financing of outsiders and the generosity of others. In some cases, those gifts those donations comes with sort of strings attached to them with, kind of dictating how those donations are to be used. So failing to kind of, document that and use those donations for that purpose can lead into trouble. And then the last two that I guess I wanted to talk about, and the one is kind of rare and it's not in the outline, is sort of these unique individuals who kind of have a special relationship with the organization. One of the hypotheticals that we're going to talk about actually kind of deals with that, and it's basically people who are it's usually people who tend to benefit from the organization's activities, and because of their unique relationship, they're kind of in a good spot to bring a claim. One of the areas this comes up from time to time is with nonprofit hospitals, and patients will bring claims, have in the past brought claims against board of directors for violating their duty of care, violating their duty of loyalty. So that's one of them. And then finally, the final one that I just wanted to just briefly touch on is, the state's attorney general can bring a claim, and that's usually in the situation where it gets to a spot that the organization has sort of divested itself from what its real mission is. And so that's kind of, this is setting aside all the other, the other claims that can come up in just with, non-fiduciary claims such as, obviously employees can always bring suits. I think probably when tax-exempt organizations get sued or nonprofits get sued, it's probably from employees as much as it is anybody else. But it's not; those aren't really claims that are fiduciary related. And I guess in closing on this part of it, I guess the only thing I wanted to kind of highlight, and it kind of gets back to the general theme, is it's really the process that you go through. And that's just kind of to touch really briefly on the business judgment rule. Courts aren't really in the business or don't want to be in the business of kind of substituting their judgment for the judgment of the directors. They're not going to. You don't necessarily get penalized for breach of a fiduciary duty for being wrong in a decision as a board. Where the liability comes up is where you haven't gone through the process to do it. So that's why, to the points earlier, really, keeping detailed minutes and really documenting all of the disclosures are extremely important, so that at least in the, sometime down the line, if a claim comes, there is something there in the record that's, that was made contemporaneously that you can turn over. That really benefit, that's a tremendous benefit for the organization. And again, most of the people in this room, I don't think, are our target audience for that. It's the people who are, it's the other people on the board of directors who may not show, who don't show up often. And it's tough to make sure these things happen. But making sure you have a sound policy in place and then actually following through with the policy, I think will really save a lot of grief and headaches down the line.
I think that's a good segue. Bob, you were going to address some of the protections for
Right, now.
the board of directors when they do things right.
Right. Well, we've sort of scared you with all the thing, and maybe it's not scared, but we emphasized the importance of fulfilling your duties as directors, and Mark does sort of end it with, well, if you do it wrong, you could get sued. and as I sort of said at the start, in order to encourage people to be, particularly in a voluntary capacity on boards of directors, the states and the federal government have passed statutes that move back the hurdle for liability, or make it higher, I should say, the hurdle for liability for persons who are on boards of directors of nonprofit organizations. And in Maryland, there's two primary statutes. And the first one I sort of is really oriented toward insurance. And if a nonprofit organization, it's not every nonprofit, but it does cover charitable organizations, it covers athletic clubs, condos, or homeowners associations. It doesn't cover business leagues. But basically, if that nonprofit organization maintains a certain minimal level of insurance, then it protects then The statute says that the organization itself can't be held liable over and above the limits of insurance. So only the insurance company is going to pay the liability if it's found out that the organization is liable for something.
Are we referring to D&O insurance?
No, this is regular casualty insurance, and not only does it now, of course, if there's a deductible, and there usually is a deductible, the organization is going to pay its own deductible. But the statute goes even further. It protects all of the organization's directors, officers, employees, or volunteers from personal liability, unless that person acted with malice or gross negligence. Now, the litigators here, like Will, know that malice and gross negligence is a very high standard. You've got to be really a bad person to have gone to that standard. So now the minimum, and the statute has the minimum limits of insurance, and they change from time to time, but it's currently you must have insurance that covers $200,000 per claim and $500,000 in the aggregate for all claims that are from the same occurrence, and this is in the handout, or $750,000 per policy year and $500,000 for all claims that arise from the same occurrence. You also must have a deductible that is no higher than $10,000. So if you have this insurance, it really is a real comfort to the people who are on the board of directors and also to the officers, employees, and other volunteers for the organization that they won't be subject to personal liability. There's also the Maryland Volunteer Service Act, and that applies to charitable organizations, business leagues, civics leagues, and certain other types of tax-exempt organization. It protects directors, officers, and other persons who provide services to the organization without compensation. So it's somebody, for instance, who isn't on the board but offers to say, I'll fix your roof for free. They would be a volunteer in that situation and could be protected by this statute. Now, as I say, perform something without compensation. What's compensation? Will's company, or Will decides that he'll put it on your roof for you for free, but you're going to pay him for all of the materials he bought, and he'll have and I don't know, I haven't looked at the question whether that would be compensation. I suspect it wouldn't be, at least if you structure it properly. But you also say, okay, now Will can use as an advertisement, I'm the roofer for the company that protects the needy. I don't know, that might be compensation, but I guarantee if you got a plaintiff's lawyer, they'll probably find a way to at least make the argument or at least follow it through. So, and the secret's to watch out. You give somebody $100, $500 because they did all this work for free. They now got compensation, and they moved outside of the statute outside of the protection of the statute. So basically, what does the statute do? It says a volunteer is not liable in damages. So anybody who claims they're damaged, could bring a claim with respect to his or her own acts, unless the act or omission constituted gross negligence, reckless or willful or wanton misconduct, or intentionally tortious conduct. That's conduct that intentionally harmed somebody. A little bit different standard and a little bit lower hurdle to cross than with the insurance-oriented statute that I mentioned. It also protects a board member from being sued because he or she approved of or because of the actions of somebody else in the organization. So you've got somebody in your organization who commits an injury, who injures someone else, and somebody wants to bring a claim against the board members. Well, you hired this person, we're going to sue you as well as negligent responsibility. This statute would protect the volunteers unless the volunteer knew or should have known of the act or omission or authorized or approved it. There is a federal Volunteer Protection Act, which applies to all states, not just to Maryland. It is, in most ways, it's not quite as broad as Maryland's, and the central rule is whichever statute gives you the better protection, you look to that one. So if you were in a state that didn't have a Volunteer Protection Act or had a very weak one, you can look to the federal state. In Maryland, it's generally the state act. And one thing to note, a number of tax-exempt organizations set up for-profit affiliates. this Volunteer Protection Act would not apply to the for-profit affiliate. Two other things just to note here. One is most organizational documents of tax-exempt organizations, like organizational documents of for-profit corporations, provide indemnification. So if you read your articles of incorporation, likely there's a provision in there, and if that would say that if somebody acting on behalf of the organization is sued, the organization will step in and pay the judgment against him or her unless they've committed, again, the kind of bad acts like willful malfeasance or tortious or gross negligence. Some of those organizational documents provide that the organization will fund the defense cost in advance. Others don't. If I'm a director on a board and I'm serving, I might like to see that in the organizational documents, because the truth of the matter of most of these cases that are brought, a large number of them don't end up getting judgments against the organization or the individuals, but you can burn through an awful lot of legal fees defending yourself. And the final thing I'd mention is another insurance, an insurance some of you may have heard of, which is directors and officers insurance. And that, is something that if you're serving as a director and the organization gets directors and officers insurance, you're sued personally, that D&O insurance will step in and pay the cost of defense and pay a judgment against you within its limits if indeed a judgment were found against you. And I can't emphasize the importance of covering defense costs, because, again, as I said, they can be more than the judgment actually is.
Okay, now we finished up with that kind of brief synopsis of the duties and obligations and what can happen. We now have three hypotheticals where I really want to open it up for discussion. And essentially, I'm going to start with hypothetical number one. This is your chance to ask questions, hear your input, and we can brainstorm together to get to a better understanding. In the first hypothetical, it's pretty long, but I just want to briefly explain. Here to Help is a local nonprofit hospital that's providing medical care to low-income individuals for over 50 years. They've expanded and have a substantial endowment. They have a board of directors, and Jenny is an employee who is involved on a day-to-day basis handling the matters of the nonprofit. The board has established a 4-member finance committee to handle the investment of the donations. And Jenny, who's wishing to be cautious but without consulting the fellow committee members, deposits 95% of the nonprofit's funds into a non-interest bearing account at We'll Take Your Cash National Bank, a local bank where her husband serves as the chairman of the board. She does this for the next 5 years. While she's occasionally questioned by the committee members, they never have a formal board meeting. The larger board receives periodic financial reports and never questions her investment strategy. Several years later, the fundraising decreases and there's an economic downturn. The organization quickly runs through its reserves funds, and there's concern that it may not be in a position to provide even the most basic care. Several patients of the organization have joined together to file a lawsuit alleging, among other things, that Jenny, the members of the finance committee, and each member of the board has breached their fiduciary duty. Should the board members be concerned? Who do you think?
The answer's
Who
not
sees
no.
the red
The answer's
flags here?
Lots of red flags.
Name a couple red flags that you see.
The board didn't make the decision to invest the money. The employee decided on her own.
Well, in the first place, why would any one director of the board have the power to take the money? Those things should have been set up in the beginning, that no one person can write a check for X amount without the entire executive board being aware of it, yada, yada, and that wasn't done in the beginning.
She wasn't a director, she was an
And aren't
employee.
Well,
No,
she's
no,
an employee and
director.
She's an employee and
Oh,
and a director, which is very common. You have the
Which is
CEO of the
common.
organization, that he or she can sit on the board as well, and often is the instrumental force on it.
Well, I'm not in favor of employees being board members personally. Even though it might be legal, I don't like
Yeah.
it.
Go ahead.
Potential conflict of interest with her husband. Obviously,
That's a biggie.
That's a fairly large one, right?
Carl, you had it?
No, I was just going to say that, we're focused on the investment strategy, but we also have some other problems here because you have a board of directors that's actively disengaged from this
They're
organization.
asleep at the switch.
And so what you've done essentially is you've got this organization essentially going bankrupt. Why? Should somebody have seen not just the investment strategy, but should someone have seen the need to engage in different fundraising or changing the model or something of that nature? So while the investment strategy certainly hits you smack in the face, there are potentially other issues here that are going to, in my mind, expand the sort of dollar figure that these board of directors might be responsible for.
I just add this, the investment strategy they had, it was a conservative investment strategy. You often are, faulted for a more aggressive, i.e. Madoff type of investment strategy. Conservative investment, if the board had actually looked at this and said, we don't trust the markets. We want to be conservative and protect our principal, they'd probably be okay. But they didn't do that. That's the problem. And Carl's right. That when you don't do that, they're not looking at the financial picture at all.
So before the lawsuit happens, what can the board do to fix this situation the red flags that we've identified?
Well, I think, obviously, I think that they kind of went a few steps in the right direction. It's not uncommon to have a finance committee set up to deal with that, but it has no oversight. One is to make sure that to demand some sort of accountability, which went, and I think, to Carl's point, it's an issue. The investment strategy is the biggest issue that kind of hits you. But really, I think the one that gets the board members in potentially more trouble here is the fact that they are so disengaged with how, with just basically with a very fundamental aspect of their enterprise. So making sure that there are procedures built into the organization's, operating documents, or making sure that their policies are in place and procedures are in place that, that they have consistent board meetings, that the financials are reviewed periodically, that they, every so often, every 6 months, or whether it's 6 months, a year, quarterly, whatever, sit down and, as a full board, look at where they are and budget out where they're going to go. None of that happened in this case. So that's
an answer to Will's question. What can they do now? They're in a hard spot because they've already made these mistakes.
Right.
You can't unmake the guilt by omission of the board members in the past. They've also got a very serious damage control problem here with once this gets in the press. When the lawsuit's filed and it's in the press, and the press gets a hold of the fact that the board members were so disengaged, and also the conflict of interest of the investment of the funds with the person's husband's bank. Yes.
Is there a question?
Oh, no.
Okay. I think the first thing, the board has to get engaged. They have to address the problems. They have to start understanding where the red flags are and take steps to remediate that. Jenny shouldn't be able to have that same kind of level of control over the finances. Steps can be taken proactively once you identify the red flags to avoid future problems down the road. The worst thing that can happen, though, is the board ignores nothing and ignores the problem. Any other comments, questions? Go ahead.
With that, Will, and this, say that particular case moves forward, with the court then would take that into consideration. Oh, the board folks woke up and now they have a new volunteer that's a CFO or an accountant, and Jenny doesn't do that anymore, and the money's been moved into a bank that pays interest, 1% interest or whatever.
I don't think it's going to rectify the past. It certainly will. Number one, it'll give you an organized way of dealing with the lawsuit. So you now have a board that's paying attention. And I think that I won't mention the organization. I know there was some press about a educational institution around here that had similar issues, and the board got a lot more engaged once they found they had a problem. And there was a lot of press it. And then there was fights among the board members as to how we should handle this, but it doesn't remove the past. It certainly may help with the image issues with the press.
And to Bob's point, the image issues, I think, can be more dire than the actual liability issues to the directors. I mean, because, like I said, these organizations, the lifeblood of these organizations is public trust and the ability to continue to raise funds. If once it's a very difficult thing to build up, but it's a very easy thing to sort of throw away. And so trying to get out in front of it at this point, while it's certainly a daunting and uphill task, that's certainly a step in the right direction.
I'd mention one other thing, as directors on the board, if this thing hits, some directors' first thing to do is, I'm going to run for the woods and I'm going to resign from the board. That doesn't help. You're better off to stay on the board and say, let's deal with the problem.
Right.
Because I can help. Now I can do maybe what I didn't do, but we can work on it together to try to, tamp this thing down so it's not a complete firestorm.
But if you're on a board and you don't feel that the other board of directors are as engaged as they should be, should you step off the board?
I think, the first thing you should do is really make an issue of, we need every director who's here to be involved. You got a job as a director. And then if the rest of the board won't support removing or putting certain requirements on the board members to continue, then I think you have to wrestle with, you're sort of subjecting yourself to a risk by being on a dysfunctional board.
Well, and that's where the business judgment rule applies as well. The business judgment rule, again, applies to the director who's doing what a reasonable business person would do while they're sitting on the board. And if you do that, if you make the issue, if you send the letter, if you document, I'm opposed to this decision, later on, heaven forbid, there's a lawsuit and you're named personally, you can step forth your defense of, listen, I was very reasonable here. I oppose this, I object, I voted against it, I tried to take corrective steps. And so those are the kinds of things that, as a board member, obviously you don't want to be looking around all the time, but you do want to be taking the steps of what you would be doing if you were on the board of a for-profit corporation. Let's move on to the second hypothetical while we have time. This one's a little easier. TEO was formed to carry out the mission of feeding underprivileged families. Beatrice Crocker is one of the board directors for TEO, as well as the president of a regional food distributor, Good. Betty wants for her company to sell food to TEO at its most favorable rate. She discloses the potential conflict of interest to the board, but does not want TEO to bid out the project competitively because she feels she's doing the organization a huge favor. This is the roofer scenario we've been talking about. How should the board of directors for TEO handle this situation?
Bid it out.
They should bid it out and see what everybody else comes back at and make it be competitive.
Even if that means you lose a board member?
Yeah, what happens is when Betty says, I'm not going to do it, you don't trust me,
Well, the organization's
Too bad.
safety and reputation and everything else comes first.
Yeah,
Sorry,
the
Betty.
organization has to come first.
Yeah, your fiduciary responsibility has to
Fiduciary
overweigh
responsibility, exactly.
feelings. In my mind.
Is there a compromise?
Yeah, the compromise is Betty says, I know who you ought to bid it out to, because these are two, and they're reputable companies, but you know that the wheels are turning in her head, and she knows they always come in a little bit higher than her. And she could say, look, I'll show you my standard rates. I'll show you, of course, nobody has standard rates. They all cut them, but I'll show you my standard rates, and I'm giving you a 15% discount. So once you get into that dialogue with the board member, Betty, yeah, you've already got a problem. And let's just change it a little bit. Let's say Betty is a key contributor to the company. It makes it a little harder to have that confrontation. If she's just a board member you brought on because she was interested in your cause, maybe it's not as hard. Yeah.
I think the easy way to handle that is to simply have a written policy in place that says for any of these things, we're going to get three bids, and if someone on the board wants to be one of those people, they can do it, but they're going to be excluded essentially from the deliberative process. But if you have a written policy, you can always fall back on it and say, boy, we love you, thanks a lot, you are a key contributor, but we've got this document we all agreed on, we've got to follow what's in
And
it.
that really takes the politics
And you're
out of
done.
it,
Yeah.
you know, and because like it's the type of these things, this hypothetical in particular is, you know, it's very easy to, you know, we can all spot it real easy in black and white. It's really easy. It's really succinct. The problem with it is you don't have, you know, these don't happen in real. It's not this neat and tidy in real life. There's difficult conversations to have with people on the board, particularly those who are, you know, who are big personalities and who are donating their time. It's a very difficult thing to do. And nobody says it's easy, but that's a great idea, is to have something in, you know, something that you can kind of hide behind as a shield.
This is why Carl is the chair of my board. Don't any of you think you're going to approach him anytime soon. Just saying.
Let me add that some of this type of hypothetical creeps up. You know, somebody will do a little bit something for you at under rate. It's not, you know, you're not bidding out the $20,000 job, but they'll do something for you and they'll charge less than normal. So you sometimes end up in these situations, well, what's different today than what you did 6 months ago? And again, I think everybody's reaction seemed to be, yeah, you know, bid it out. And that is the answer.
Any other, I mean, suppose you don't have the conflict policy and you've identified, ooh, I'm on the board and I've noticed that we've been kind of helping doing this informally and have this. What can you do to get the board going in the right direction?
Well, I mean, I think part of I mean, you can do a variety of things. One is to get a policy. I think at that point, elevating it and getting a policy in place is obviously important. That can be difficult to do in and of itself. But I think, again, you know, not to keep kind of beating a dead horse here with making sure it's documented, raising your concerns on this and saying, look, this is sort of, and particularly in the case where you have sort of a creep on one of these things, where it's just kind of like you look around and say, you know, look at how nice, you know, look at all the nice things Will has done for us. Then you wake up one morning and say, holy cow, he's done, you know, we haven't really thought about whether or not, you know, we've deliberated on whether this is appropriate or not. You know, it's taking steps and just, you know, reminding everybody that they signed up to, you know, to put the interest of the organization first, and reminding them also that there is potential exposure. I mean, limited as it may be, but in order to make sure the organization is running, you know, as smoothly as possible, and to avail yourselves of some of the protections that are available, statutorily or otherwise, you know, taking it upon yourself to try and create a policy at that point, I think is a great first step.
One way to also emphasize and bring it up is so it's not just we hate Will. It's to, you know, go pull something off the internet. Maryland Secretary of State's office website has a lot of good material on what you need to do as a tax-exempt organization. So it's not just, you know, you're doing it out of a personal vendetta or distrust of somebody, but you pull it off and you say, well, or even take an outline like this and say, this is what we should be doing. You know, we've got our job to do, and yeah, maybe we haven't been doing it in the past, but let's try to correct things here.
Okay, let's move on to hypothetical number 3. An old house is a tax-exempt organization that was formed to maintain a large historical home that was built in the mid-19th century. It was initially funded by the family that owned the home, but which could no longer afford to maintain it. The organization has traditionally used the home only for tours by school groups and during the holiday season when it is decorated. New board members who have made significant contributions to an old house want for it to expand its mission to include using a portion of the home as a residence for visiting scholars interested in area history. Family board members of an old house strongly object to this change of mission. What can the board do?
Let me hit this. There's a couple other facts. I'd like to fill in a few more facts here, since we came up with the hypothetical, and then when I read it over, I say, well, let's make it a little, I can't say more complicated, but maybe even more real life here. This organization was set up a while back. The bylaws actually, since it was set up by the family, the bylaws guarantee the family 3 members on the board of directors. And the bylaws don't say how many members you have on the board of directors. So for decades, the family has been controlling the board of directors. But 8-10 years ago, they realized, you know what? We don't get enough money in to support even maintaining the house the way it ought to be maintained. So they brought in some heavy hitters who could help raise money. In fact, they brought in so many heavy hitters that those people now, they expanded the board and they control the board. So, and the heavy hitters have been very successful in raising quite a bit of money. So it's no longer the impoverished organization it used to be. And I think that puts a little spin on this, because I think earlier, it was a question, what's the mission of the organization? Well, you ask the family member what the mission was. It's to maintain our house like our great-grandparents had it, and they can, great-great-grandparents, whatever, back in the 19th century. To the new board members, the mission may not be the same. So it turned out, just thoughts, different people have thoughts on what ought to go on, happen here.
Is the mission not the same, or is it just that they're widening the scope of the mission?
Well, let's turn to the articles in incorporation. As I said, you should look at, I think Mark had said, the duty of obedience is let's stay on mission with what the articles say. The articles of incorporation say it's founded to respect the history of Montgomery County as evidenced in this particular structure. But, like we do when we set up tax-exempt organizations, we do all the time. We just want to make sure if it expands its mission somewhere along the way, it'll be covered. So there's also, and to do anything else that a tax-exempt organization can do that's consistent with Section 501c3 of the Internal Revenue Code. So you got a specific mission, but you got whatever else the organization could do.
How do you resolve a conflict when there's on a board? If there's factions fighting, well, what can you do?
You have an open discussion, you have a vote, and that's it.
Or compromise.
Or
consensus. It's a quorum decision. And also you've got some founder syndrome going on here, which is also really, really, really difficult to manage.
It is hard.
It would have to be done.
Founders tend to be very charismatic and
Well, here it may be
intimidating.
different. Here, because the old founders are gone and it's the family members.
Well,
Yeah, I mean, well, let's just, but it could be.
descendants of the
It could
founders.
be. I mean, they're focused on a very narrow mission.
It's very personal for them, so it's really,
But basically, they're maintaining their family home, and it's tax exempt because they let a few school groups in and they decorated it at holiday time because they like to show off the house.
Carl?
I was going to say, the first thing that came to my mind, I think you've touched on it, is I would look at the Constitution or the Charter to look at the scope of the organization. And if the scope of the organization was such that it didn't fit, I think that then the board, what I've heard you say earlier is it's important to be deliberative. It's important to have open discussion that is not infighting, but that you listen to what everyone has to say, you carefully consider it, and you make a decision as a group with whatever the majority says, as long as it fits within the parameters of the Constitution, of going in a particular direction. And I think as long as you have that open, deliberative process, yeah, you're going to get some feathers ruffled. I mean, you can't help that because the sort of scope or the mission of boards change over time. And some people will be okay with that and some people won't. Some people will have to quit and some people won't. But I think that's just the nature of being on a nonprofit.
I think what happened here, if we really look at it, is the founders' family, maybe if they really wanted to keep it on this narrow mission, they goofed. They goofed by letting in other people who have a broader vision and letting those people have control by making the board so large that they could no longer control it.
Ellen had a question.
Yeah, just commenting, kind of back-ending that, is it's also a financial decision as well. Because the reason why they decided to expand and bring in more board members was financial.
Teresa?
So you might want to bring in an objective person, have a strategic planning session.
That's actually a good idea. Some mediator to make it so that people aren't sort of down each other's throats when they're talking about it, because it's probably very emotional for the old family. Yeah.
Well, it seems like for this scenario, you're kind of trying to go back and backfill solutions to problems. If I were encountering an organization that was planning on expanding, it had been a family organization, I think prior or as part of that expansion, we would have to look seriously at what are the expectations of the older board members or the previous board members, the family itself, and how they even envision a board expansion helping move the physical site into the next generation. This is actually a scenario that plays out in historical home circles all the time. So, in the late 80s, the question started to be, how do you keep the doors open to historical homes? Most of them are, collections, attics for, family legacies, and that in and of itself doesn't get people into the door. So I could, and I won't, but I could name 5 organizations in this county that have been in operation along these lines for the past 50 years that have encountered these very problems. So I think as you're expanding, you have to have that expectation, which of course at this point you can't go back and do. So if you're going to bring others on, you have to, really sit down with the owners, that family, and decide, is this the step that they actually want to take? One solution to this is to really take a sharp look at the mission. The proposal using portions of the home for visiting scholars, that might seem like a change in the mission, but if that is tantamount to creating a residency program, then those scholars could be required for use of the space to actually produce papers or program that further memorialize the legacy of the family and the history of the home.
That's
itself.
probably, that is
So
not a
then you have
bad
win-win
compromise
situation.
way of looking at it. Well, there's some benefit for the family itself in doing that.
I'm going to open up now the floor to any questions generally on any of the topics we've talked about. I think we did a good job going through the hypotheticals, and I wanted to give you, the audience, the opportunity to ask questions if you had any about your boards.
I wanted to ask you, talked earlier about confidentiality in a board meeting, but how do you address that when you have open meeting laws?
What was that?
The confidentiality with open meeting laws.
So this would be governed by statute, so it's like a county or
Right.
I mean, if you have to be an open meeting, unless that's
That's right.
something that you can,
Right.
override in executive session, I don't think you can override the open meeting laws now. I'm honestly not up to speed on those. Can you have a conference in the hallway and you talk and it's not an official meeting? I don't know.
I'm not up to speed on it to any significant extent either, but I echo that, in that if it's going to violate another legal obligation that the organization has, obviously you can't do that. So but it's just more of an idea to try and keep things that can be kept internally without violating any laws internal.
Yeah, I think the answer is you have to comply with the law, but as I understand the law, there's usually some room to have closed door sessions on certain vital, sensitive areas. And again, as long as the board is going through the process and understanding, okay, we have this statute and this obligation, we have our bylaws where we want to maintain our confidentiality, as long as those reasons are addressed as to why the board thinks we can have this discussion in closed door session, again, it helps a lot more when you document and go through the process to help maintain those obligations. Other questions?
See, we answered everybody's question.
That's right.
Yeah, first of all, this is a great presentation,
We didn't scare everybody too much?
Not me, too much. But I guess one of the things, it seems that in operating a board, there's the stuff that's kind of, right in front of you all the time. And then there's the stuff that should be in front of you, but you don't even know it exists. And what I'm wondering is, are any of you aware of any kind of master list of questions? Maybe something that Maryland Nonprofits or some organization puts out that would allow a board to kind of go down multiple checklists and fill in those things that you may not even be aware of.
I mean, I'm not aware of any particular lists that have been published. I mean, I think, in general, one area that may, that serves as sort of a good guidepost, I think, honestly, is a lot of the questions that come up on the 990 on the tax return. Like, that, not necessarily that's the end of it, because that doesn't necessarily mean that there aren't things going on behind that you're not sure of, but that those, specifically with respect to tax exempt entities, sort of flush out. There's a lot of detail in a full 990 anyway, in terms of what what the obligations are and how the the organization's fiscal strength and outlook going forward. But again, I think as important as any of it is to just make sure, that collectively as a board that you have a discussion to come up with like a set of things that you're going to ask or kind of check off. And if that needs to be adapted or revised, be somewhat nimble and do that. And just trying not to turn the willful blindness is sort of, it can be a problem. I don't know if you had anything.
No, I'd say I'm not aware of a particular checklist. I would suspect, but I've never looked for it. You can probably find one on the net, but I don't personally know of one.
I know you very well, Tony. I'm a former board member of his, and having served on many other boards and consulted for boards too. There's a lot of great checklists on the internet on board best practices. It's not necessarily the legal, but it's the things that every board should have in place, like a board member orientation. A lot of people are just invited on and like, okay, now what do I do? Have an orientation document, have an expectations document, have a checklist of, what their skill sets are, so you can assign committees more thoroughly. And a lot of this, you might want to write this down, is on BoardSource, BoardSource.org. And a lot of it's free. But that's where I think people start getting in trouble, is they join boards, but they don't necessarily have an expectations or an orientation up front of the number of meetings they must attend, attendance policies. If you can't attend in person, be on speakerphone, because your vote can still count. You don't have to physically be in the room, these sorts of things. So.
I encourage everyone to keep learning. I want to thank again everyone today for their participation, their questions. In particular, I want to thank Bob and Mark for their time and commitment to presenting today. I also want to highlight Jeannie Price from our program committee, and our executive director, Sarah Burnett, who did a lot of the legwork to make this happen today. Thank you very much, everyone, for coming.